Serious, solicitors, lawyers, what's the worst case of you should have mentioned this sooner you've experienced? Spent several hours zealously arguing that my client was severely disabled and couldn't work due to a back injury. It was so bad that the poor dude couldn't even sit in a chair throughout the entire proceedings. Rest my case. Opposing counsel calls in a DEC representative who proceeds to produce record after record of my client's deer hunting activities. He sat in a tree, in freezing weather, for many hours, shot and killed multiple deer, and transported their carcasses out of the woods all on his own. SMH. In-house attorney here, but I interned for a judge at our Court of Common Pleas during law school. There was a case of a guy that asked two early 20 girls a ride from the mall to a gas station. He told them he would pay them cash for the trip. During that trip, he sat in the back seat and had advised that he had a pellet gun that closely resembled a handgun. He said he had only pulled it out to show the girls but never did anything further. That had been his testimony during all the proceedings. He willingly takes the stand and the prosecutor is questioning him about the gun and how he handled it. This dude willingly admits that he held it to the passenger's temple, threatening to shoot her with what she believed to be a real gun. He also corrected the prosecutor during questioning, telling him that he never stated it wasn't a real handgun. That jury verdict came about as fast as one could. Sometimes I wonder about my own level of intelligence. Am I as smart as I think I am? And I don't consider myself to be particularly smart. Then I read something like this, say a little thanks, and have a generally good day. More than 59 children. Special ed case. School district was supposed to be providing services to the child in the home. Clients told us the school district had never sent anyone to provide the services. They hadn't heard from anyone in the district about scheduling, etc. Brought us up during a pre-hearing conference with judge and opposing counsel. After the conference, opposing counsel sends me pages of affidavits and documentation of all the times the school district employees went to the house and were refused entry by my clients for various reasons, or clients just didn't answer the door when they were clearly home. Clients had no explanation about why they lied to me. They fired us shortly after and I was not sad. More than 69 children. I had a client charged with shooting and paralyzing victim. He was ID'd by a woman in the house that knew him, but the witness was potentially biased. Client says he wants to fight the case. We then discuss whether it should proceed time waived or time not waived. The difference is how quickly the case is set for trial. Time not waived means the trial is set within 60 days. Time waived means the trial can start in more than 60 days. The importance was that my client told me he was not at the scene. I stress the importance of being honest and that everything is confidential. He again said he was not at the scene. I told him we could get cell phone records to confirm that his phone was not at the scene of the crime at the time of the shooting. And if we could show that it was active, meaning he was using it, it could help cement his alibi. I also said, but if you were at the scene, we should set this time not waived so the DA can't get your cell phone records. Client says to set it time waived and get the records. So, several months and a lot of work later, the cell phone records literally show him at the fricking crime scene at the time of the shooting. It also led to more evidence more directly linking him to the shooting. The records also managed to implicate his friend as being involved. It tuned the case from being borderline to a slam dunk for the DA. It's even more ridiculous than this, but it's kinda off topic. Edit. Okay. Some more of the ridiculousness. I share the details of the cell phone data with client. He has no reaction and offers no explanation for his prior statement that he wasn't at the scene. I explain that the DA does not yet have this information, so we should try and accept a deal now before the DA finds out, because he will most likely revoke the current offer when he does. Client insists on a jury trial. I explain that it's client's call whether we go to trial or not. I'm here to offer advice. and he's free to reject that advice. But I think it's a really bad idea because the DA will get the info before trial. When he does, the offer is going to skyrocket. Client continues to insist on a trial. My final words are, that's your call. But commit to your decision. If you reject the current offer, then try and plea later, the offer is going to go through the roof. If you want to plea, do it now. You guessed it. The jury is literally walking into the courtroom and I hear this, PSHHHHH. PSSSST. I look over and ask him what's up. He says, I know you said not to do this, but I want a deal. He pled. Because of his shenanigans his offer increased by roughly 300%. He would be out of prison if he took his original offer, and I think he has well over a decade to go currently. There's actually more but I don't think I can share it because it's so unique that it would make it easy to identify the case. Edit number 2. Wow, thanks for the award. My first. My client was badly hurt in a car accident and promised me he was never hurt in one before. He was actually hurt in 44 prior accidents, all of which he filed claims for, which is how I found out when the mediator showed me the defense's ISO report. The frickin' look on my client's face, LMAO. Client comes to me with his new wife, complaining that he's been sued by his ex-wife for failing to pay a $5,000 judgment to the ex as part of the divorce decree. Judge orders us to mediation. During mediation, ex-wife won't budge that she wants the full $5,000. Client claims he doesn't have the ability to pay it. New wife, in an effort to get her loving husband free from the clutches of his evil ex, offers to give up a large diamond wedding ring to the evil ex. Ex can keep it, sell it, whatever, but client had previously told new wife it was worth more than $5,000, so it should be enough. Ex-wife agrees to accept new wife's ring, subject to an appraisal. Maybe you can see where this is going. Get a call 2 weeks later from opposing counsel, deal is off. Why? I ask. Turns out the ring was a CZ, worth about $95. When client met with me and I showed him the appraisal, he said, yeah, I knew that was going to happen. I stared at him slack-jawed and said, you knew? Oh yeah, but what was I supposed to do? Tell my wife I got her a fake ring? How about telling her, no my love, I gave you that ring, and it is a symbol of my love for you, and that horrible bee will get it over my dead body. I'll find another way to pay her, I said. He looked at me and says, yeah that would probably have worked. Right double quotation mark. A person involved in a motorcycle accident, who sustained legitimate but not serious injuries. CCTV showed the incident. They were very much not at fault. They'd decided this was their big payday, claimed they could barely walk, had PTSD, serious back trouble, would never work again, the whole 9 yards. They neglected to tell their lawyer they had been, working a manual labor job, riding motorcycles again, did a bungee jump. All of which we caught on video they documented via social media. They did not get the multi-million-pound settlement payment they expected and were pursued for fraud. It was a fun phone call after we sent the tape full of evidence. Special education case. Mother and school were fighting about services. We got new assessments that backed up the mother's claims. Local school didn't have the right services, so we arranged a transfer to a larger school not too far away. Good public transit route, some extracurriculars kid was excited about. She goes to enroll him in school, says they have a problem with paperwork. Thinking the transfer info just didn't get there yet, I take a copy and head down there. No, they won't enroll him because not his legal name. She is not his legal mom. Turns out, she was the BFF of a mother who was pregnant and about to be incarcerated for drug trafficking. BFF says, can you take my baby while I'm in jail? I'll get him as soon as I'm out. She and husband say sure. They sign a piece of notebook paper. 12 years later. SMH, you have to think, how did they manage to navigate school and medical stuff for 12 years with no legal custody paperwork? They'd just been using an assumed last name of the pseudo-adoptive couple and, like me, no one had asked. Was only that the school had moved to an online system that checked SSS against other databases that it was caught. Anyway, bio mom and dad were still alive and still in a lot of trouble. They consented to the couple that raised him adopting. Kid missed a week of school while I convinced them that he fit under a homeless youth school stability statute. Edit. Yes, it was the couple that had raised him those 12 years that adopted him. That's heartwarming, not just that you got that kid into school, but that the mom took look after my kid while I'm in jail to that level. Were the folks who raised him the ones who adopted him? I filed a bankruptcy for a person. A few weeks later, they indicated that a creditor continued to contact them and had taken money out of their bank account, which is obviously a big no-no for people in bankruptcy. It was Monday. I knew that if I wanted to file for sanctions, I had to file the motion by Friday, so I wasn't going to jump right into it. It's best practice to try to get the creditor to correct their behavior first. I called the original payday loan store. I called the national branch. They took messages daily, nobody was contacting me back. I asked for supervisors. Nobody was willing to talk about the situation, and I became increasingly frustrated. I'm not a yeller and I'm not particularly forceful, but even I was reaching my limit. I called my client daily to explain that it made no sense that they were being evasive, but I was working as hard as I could. On Friday, I talked to some low-level grunt and explained that I needed a call back in an hour from a person who can clarify the situation, or the sanctions motion is being filed. I read off my time spent on the case, which would translate into thousands of dollars in sanctions if we were successful. I finally get a manager. He, very politely, tells me that the client took out the loan after the bankruptcy was filed. I remember deflating like a pop balloon. My client had taken out a relatively big payday loan a week after the bankruptcy. They confessed that they knew it wasn't included in the bankruptcy, but thought the lender would go away if an attorney got involved. That's probably mild compared to the things that I see in bankruptcy, but most I probably shouldn't disclose. One of the major tenets of bankruptcy is that a debtor has to make a full and honest disclosure of their income, expenses, assets, and debts, so naturally, there are tons of reported cases of people hiding things to try to get out of their debts without surrendering assets. I was representing a man that was accused of sexually assaulting the young daughter of his girlfriend, who was married to another man. The key issue was whether or not my client's DNA profile should have been at the scene. Only skin cell tissue had been recovered, not seminal bodily fluid DNA, and it was not an exact match, but rather a match to a profile that included him. A few weeks before trial he finally told me that a woman's other son was likely his. They had been having an affair for more than 5 years. The fact that the boy shared his DNA was a pivotal reason that the DNA profile would have been present. Edit. Grammar. A big issue was a language barrier as my client did not speak English and we used an interpreter for all of our communications. I had a client on a family matter. We were in court and I was going on about how being a father was the most important thing in the world to him, and his ex pipes up and says, well, he never sees his other children. I'm sorry, other children? That being said, many clients leave out embarrassing things until they get called out on them. Please tell your lawyers all the facts. We've literally heard everything and really don't care. Just let me prepare to explain that your weekend habits of cocaine and ex-dungeons doesn't affect your ability to parent. Had a guy with a DUI. Asked about any criminal history, he said no. So I started the paperwork for him. It's a first-time offense program that seals the record and drops the charges once completed. Get to the courthouse, talk to the DA, find out the guy had another DUI a year prior. Also was on probation from the first one still. His excuse for not telling me was the first DUI was made up and he wasn't intoxicated, but pled guilty anyway. Unfortunately I ended up representing him for both bases. Did not get paid nearly enough for the S I went through, but I did manage to keep him out of jail so he could take care of his elderly mother. Made him give up his vehicles though. Had a client charged with being a convicted felon in possession of a handgun. She had been in a car that had gotten into a shootout on the interstate, in the middle of the night in a rural area at least. She was the passenger and her car pulled into the state trooper post in the county I practiced in. Her car was shot to S so it was obvious something happened, but there was a gun in the car. She had a 30-year-old felony theft conviction, so she was charged. She had some crazy story for what happened but it was obvious that it was a drug deal gone wrong. However that didn't matter for her charge really. The discovery was really light. The driver of her car wasn't a convicted felon, and it didn't appear the state police had investigated the fact there was another car obviously shooting at my client even though the genesis of the shootout was just up the road in that same post's jurisdiction. Short of it was she had some legitimate defenses. I had met with her multiple times, discussed her case in depth, and was preparing for trial. About 2 weeks from trial in passing she mentioned that a state trooper had interviewed her at the state police post, which was annoying because at this point the case was 7 or 8 months old. So I look through the discovery again, don't see anything, but file a motion asking for any recordings of interviews. Sure enough the prosecutor was sitting on it, which is shady as frick, unethical, and common practice for that prosecutor office. I get the interview and all of 4 minutes and she tells the cop not only did she know the gun was in the car, but that she had been the one shooting. That pretty much killed every defense I had. We had a come to Jesus talk the next day and she took her offer which was the minimum of 5 years to serve. As a solicitor, one of the most annoying things I've had happen was, after an hour-long consultation with an older couple about changing the husband's will, the wife hands me a letter from his doctor which says the husband has dementia and does not have capacity to sign medical documents. Like, you didn't think that was a good place to start? I was on the other side, but I saw the other lawyer seem to have one of these moments. So the plaintiff sued saying the insurance company had improperly denied her claim for homeowner's insurance after her claim for property damage had been denied. I don't know what she told her lawyer, but as the examination under oath, like a deposition, proceeded and I laid out more of the details, I think the other lawyer understood. So basically if a pipe bursts in your house and causes water damage, that's probably going to be covered. There's generally an exclusion that says you don't get coverage if the pipe burst because you didn't take reasonable care to keep it from freezing. This person left her upper Midwest home at the end of the summer and didn't come back until like March. Didn't winterize the house, didn't shut off the water, didn't make sure the heat was on, except for a tiny heater on the second floor, and didn't even have anyone checking on the house. Well, pipes froze and burst all over the house. The water utility calls her and says there's a lot of water going through your meter. You might have a leak. She calls someone to go check on the house but they can't get in because the fricking door is frozen shut. Frick it, they abandoned further efforts to check on the house. The water utility sent someone out and they figured out that many hundreds of thousands of gallons had gone through the meter and they cut the water off at the main line. She doesn't come back until spring. Over time, there was freezing and thawing, then when it warmed up the place molded through and through. Everything in the house was completely fricked. If I had to guess, she left out a lot of those details when she described the case to her lawyer. There was a temporary order of protection in place, and we went to court on the lengthier order of protection. I talked strategy with my client the night before, but unbeknownst to me she reconciled with her abusive bag baby daddy. I had 3 OP hearings that morning, and did not get a chance to talk to her until 3 minutes beforehand. We had the wrong judge. I knew as soon as she told me she was going to be arrested for violating the temporary order. Sure enough, They both got a week of jail and I had to watch their 3-week-old child for a few minutes before a bailiff carted her off to God knows where. They both got fired for missing a week of work. They couldn't get the kid out of the system. Evicted, homeless, the whole 9 yards. All she had to do was tell me they got back together. All she had to do. Criminal defense, Canada. Talked to a client in cells. Said that she was hanging out at her baby daddy's and then, as she was leaving, the cops came and harassed her, so she resisted, and that is why she is in jail. Turns out she was getting aggressive with him and he kept trying to get away from her. He ended up calling the police. While he was on the phone with the police, she starts beating him up. The police hear this and immediately respond. She was trying to flee the scene after beating her man up while he was on the phone with the cops because he was attempting to passively solve the issue, but she wouldn't leave. Luckily she has no record, but, man, I felt bamboozled. I learned a healthy dose of skepticism whenever people told me things from there on out. Yeah, gotta love it. Okay, here we go. Defending a lady in a simple neighbor dispute. Neighbors said she assaulted them with a hose and threatened their kids. Case was pretty weak. BC my client was an old lady and she adamantly denied everything. Anyways, it's just a small evidentiary hearing in front of the judge, so there was no discovery ahead of time or anything like that. Anyways, my client is on the stand. Come to find out they have video footage of her smearing dog S on their house, printing out photos of their kids and writing racial slurs on them. Family was Jewish, and covering her house with racist signs, like papering her entire house. Needless to say, my jaw dropped. Client then perjured herself on the stand. They play a video where it's obviously her, but she repeats "that's not me" over and over. Most painful court moment of my life. Paralegal for insurance defense. One of my first cases, I was completing discovery with a very young client, barely 18. She claimed the city bus rear-ended her when she was slowing to make a turn. Then he got out of the bus yelling at her and screaming expletives. We submitted these responses. We come to find out months later there is actually video on the city bus, of course, of her trying to make an illegal U-turn and ramming herself into the side of the bus. Then she got out of the car and started screaming at the bus driver, who stayed silent in his bus. The video also caught her on her phone. Not the smartest person I've met. Working on a file for a non-EU company participating in a public tender within the EU. To summarize in a nutshell, when a government agency needs to build something like a building or a bridge, they have to organize what is called a tender procedure to weed out the charlatans, fraudsters, and to enter into a contract with the most advantageous tenderer. Such a procedure is organized according to strict rules, and a lot of things are public to ensure equal opportunities for every company, and to prevent bribery, collusion, fraud, etc. Serious stuff. One of the conditions to be eligible for such a tender is that your company and its directors have not been found guilty for certain crimes: egg-breaking labor laws, money laundering, corruption, as you are assumed to be untrustworthy. If you had such an issue in the past, you can fess up and try to argue this risk has been eliminated thanks to a self-cleaning procedure, getting rid of the bad apples in your company, basically. Our client assured us that they never had any such issues, were never convicted, yada yada. Just one of the many steps in a procurement procedure. Years later, when the construction was well underway, it turned out they lied and directors in their home country had been found guilty for bribery of government officials. The contracting authority got rightfully spooked and argued our client willfully lied when tendering for the contract. The consequence is that you were never eligible in the first place, and retroactively the tender should be annulled to restart the procedure. When asking our client WTF happened and why they didn't tell us so we could have tried to argue the self-cleaning exemption, they said that they didn't think it seemed relevant. It was widely known in newspapers, in the language of their home country. So they assumed they didn't have to tell the authorities, And besides, many CEOs in their home country get convicted of bribery and pardoned when the opposition party gets re-elected, so what's the big deal? Literal millions of dollars and several years of thousands of people's energy down the drain. Because they lied on a form. My cousin was the moron client. He and his second wife are divorcing and she wants full custody of the kids, no visitation, just lots of child support. He's willing to a 50-50 split, at first, and finds an attorney for the case. They're going over everything when he casually mentions how the mom drugs them literally every night so they sleep and she can go out to the bars while he works the night shift. Cousin thought this was his smoking gun to beat her in the custody battle. Attorney had to explain that, no, you can't tell this to the judge or that you've known she's been doing this for years. You'll both lose the kids and they'll go to state custody. Both of them are petty, incompetent, and as you can imagine we don't interact with that side of the family much. This has all been retold to me by other relatives. So don't worry, CPS was informed of all of this. I do not know the outcome yet, I'd have to ask. Co-suspect was defended by another lawyer, who argued in his closing arguments that there should have been a police lineup during the investigation, since the suspects were brought into the station when the victim was still there. Client turns to me and says that there had been a lineup and they were not identified. This lineup was about 30 minutes after the alleged robbery. Nothing in the file suggests a negative police lineup. We do trials based on written statements by police, they are hardly ever in court to testify. I mention what my client said in my closing arguments, the prosecutor's mouth drops and she becomes pale, hearing is suspended for further investigations. Couple of weeks later, police officers are testifying in shame that they forgot to finish the report on the police lineup. Prosecutor's case is thrown out for irreparable harm to the trial. Learned while my client was on the stand that she had a little bit of a drug problem. She disclosed immediately after that she was going to fail the drug test the judge ordered because she had been a daily meth user for years. She was stunningly gorgeous, had held the same job for over 25 years, and was a rockstar mom to a kid with special needs. Unlike 90% of my clients, she was always on time, responsive, and did everything I asked. To date, the only high-functioning meth user I've met. But frick, that hearing would have gone quite differently had she mentioned that to me beforehand. For your information, most of the time we can deal with bad facts. At the very least we can give you the advice you need to hear. But there isn't much I can do with surprise facts in the middle of a trial. Doing a complicated environmental permit case for a client. Permit was granted at the city level, but the neighbors, who were not too thrilled about a business the size of our clients being next door with loud trucks moving around all day, appealed it. They have a ton of remarks, but we can deflect most of the legal ones, and the only issues that really remain are that the plans are a tad bit vague and the noise issues, for which a study was ordered but not yet completed to give a 100% guarantee there would not be sound regulation issues. To clear up the last questions, the state body did a planned on-site visits to get clarification on the few things that were not clear on the plans and the things that were filed. My firm was not notified of this visit, and as such, we were not present during this visit. Client handled it himself with his architect. They called us the next day to inform us of the following. During the visit, state body personnel had noticed that the sewage and plumbing system didn't really appear the way it was always drawn and shown, and also granted as part of the initial permit, so they asked clients to clarify where their dirty water went. Client architect supposedly responded with, "Oh, that just gets collected and drained down to the little stream at the back of the lot." Clients wanted to know if that was bad. Spoiler alert, yes it was. There was no fixing it either. This was a company with potential environmental issues due to fluid leakage from machines and car park, so they had a ton of rules to follow on how to deal with your dirty and used water, separators, containment, early collection, and so on. They'd drawn most of these in their plans and were assumed to have all of this installed and working for the 20-something years that they had already been running their business on that site. according to their past permits, that needed to have those things. Announcing in the middle of an appeal procedure, so no big changes can be made to the contents of your permit request, that instead of a finely tuned sewage and waste management infrastructure that the government believes you have, you just have one big pipe chucking your water in a small stream at the back of your lot is bad. We had to explain to the client that no, we can't fix this, and yes, you should have told us about this from the start, and is there anything else you might have not mentioned that you need to tell us about? With some clients, mention it sooner means I never mention anything that might hurt my case. Like the case I recently had where I sued an electrical contractor based on their assertion that they had paid the guy to replace a box and he had left them with half their lights not working. What they didn't tell me is that they had an illegally installed secondary box doglegged off the first box that was controlling those lights, and he had to disconnect that box because it presented a massive danger and code violation. Then they didn't want to pay him to correct the second box. I've have plenty of cases some important fact was left out. That's why when I take notes from a client, I have them sign at the bottom that I did not leave anything out. I had a persistent felony offender early in my career who told me this sob story about how she had lost her baby and it drove her back into drugs and breaking the law. I asked her about it during sentencing. The prosecutor gets up and he is familiar with her. He leads with, "Are you still using the baby you killed 14 years ago as a crutch for your bad decisions?" Oof. That's some next level stuff with a kid. What was her and your response? My favorite, the plaintiff on the other side, so no attorney-client privilege issues here, was in court telling the judge that each of my clients, on separate occasions, raped and impregnated her without her consent. This was already highly improbable because one of my clients was biologically female and couldn't have impregnated her. Then, in court, in front of the judge, this plaintiff abruptly mentions that she's never met my clients. Easiest win I ever got. This one is the opposite of the rest, as it went in my client's favor, but I will share it because it is a somewhat funny happy story. I represent individuals who are applying for, or have, professional licenses, e.g. common nurses, doctors, real estate agents, roofers, etc. One time, I was retained by a guy who was applying for a nursing license to begin his second career as a nurse. The only problem is that this guy was previously charged with murder, not manslaughter, legit first-degree murder. He pled down to a lesser offense, but I know that the nursing board is not going to be thrilled with the idea of giving an accused murderer, who was convicted of wrongdoing in connection with the murder, a nursing license. I talk with the client about the circumstances of the murder, hoping to get some explanation that we can use to mitigate his role or put it in context. After all, he wasn't convicted of murder. But the client's explanation isn't very helpful, and, in fact, makes it worse because in addition to someone being killed, it was the result of a drug deal gone bad. In these types of situations, the only strategy is to take the position that your client is a changed man who made some mistakes in the past, but has turned his life around. Given the well-known issues with race, class, policing, the criminal justice system, and so on, this strategy, if true, usually works, since everyone should be given a second chance, and denying a license to someone who is truly trying to be a better person often reinforces the cycle. So, the day before the hearing, we prepare for hours, discussing how we are going to frame our case this way. On the morning of the hearing, the client was running late, so I had a little bit of time to kill before he arrived. On a whim, I decide to do a little research to see if there has ever been a similar case to this one. While precedent normally plays a big role in legal proceedings, these licensure cases are very fact-intensive and discretionary, so precedent is almost meaningless and not worth looking into. As luck would have it, my research leads me to an appellate decision featuring the co-defendants in my client's criminal case. In the appellate decision, the court spends a lot of time discussing the facts adduced at the criminal trial. My client pled out, so he was not one of the co-defendants during trial. Each of the 4 co-defendants has a totally different version of what went down during this drug deal gone bad. None of the defendants can agree on what their roles were, who pulled a gun first, who had a gun, who shot first, who shot who, etc. However, there are 2, and only 2, things all of these 4 co-defendants can agree on. First, my client, who was a large, physically imposing guy, was asked to join the drug deal as the muscle, but was not really told that it was a drug deal, that guns would be involved, or that there was a possibility that it could go bad. In essence, he was told that this was a routine thing, and all he needed to do was stand there and look imposing so that nobody would try anything stupid. Of course, my client probably could figure out what was going on, but these facts significantly diminished his role in everything. Second, and more importantly, all 4 co-defendants agree that as soon as someone, they couldn't agree who, pulled a gun, my client, who was hired to be the muscle, immediately turned and ran away. In other words, as soon as there was a sign of trouble, my client absolutely noped his way out of that situation, and ran like a scared rabbit. When my client arrived, I asked him why he didn't tell me these facts, since they are precisely the type of mitigating factors I was looking to uncover before. As it turns out, he was so embarrassed by the whole situation that he didn't want to tell me that part. This newly obtained information significantly helped his case, and he ultimately was given his license. And before anyone comments on how bad it is that someone like this got a professional license, I will note that by all accounts, he is a really great nurse, and truly did turn his life around. His story shows precisely why people should be given second chances at life, especially when, due to socio-economic factors, they were never really given a first chance. Eyewitness had brain cancer and sometimes had trouble recalling details, dates, etc. ever since the tumor was removed. I found out the day before trial when I asked, somewhat as a joke, somewhat as due diligence, if they ever hallucinated or forgot their own name. How about a tiny twist, with some lawyer-on-lawyer shenanigans? Other lawyer filed a document with a pretty big mistake on it. Basically they confused 2 very similar motions and mixed them up. This mistake made it useless. No evidence MSJ with traditional MSJ relief requested if anyone cares. So I go out of my way to be a nice lawyer and let them know they made a mistake. They told me, in nice lawyer talk, to frick off. I go out of my way again to say, in nice lawyer talk, that if this stupid bull's motion goes to a hearing I will be quite cross and will fricking ask for attorney's fees. In lawyer culture, this is considered a D-move. Fast forward to the hearing. After insurance attorney finishes their impersonation of a competent attorney, I explain the basic defect to the judge. I also explain that I told opposing counsel the following: what's wrong, how to fix it, and that I will be asking for fees. Then I asked for fees. After that, a few things happened quickly. Judge asks the Walnut if my explanation was accurate. Walnut says no. I reach into my briefcase and grab an email from me to Walnut. Walnut immediately objects. In a pre-trial hearing. Like a freaking walnut. Judge ignores Walnut and reads email. Judge rules against Walnut and awards fee. Walnut says I should have mentioned the email sooner. Should have mentioned the email sooner. While they shouldn't even be in a courtroom, let alone practicing law at any level. My father was handling a case of his friend's family about a property that this friend and his brothers and sister inherited. Horrible mess as you can imagine, deeply conflicted family. After few years on one of the court hearing, one brother mentioned a name that never appeared during the entire lawsuit. Turns out there was one more brother that they all decided to not mention because he was a black sheep of the family. Years of tiring work went down the drain. From what I understand, my father, who was doing it all for free because he owed him, got into argument with his friend, they never spoke to each other again, and guy found a new lawyer. More than 35 children. Here's another. I wasn't actually an attorney yet. I was clerking for a firm and helping other attorneys on cases. We had a personal injury case for a car accident. Guy got rear-ended by a very wealthy doctor. He was never going to be able to work again. Mid-30s. Life completely ruined because she was staring at her phone while merging onto a highway going 15 miles per hour over the speed limit. The case was set for trial. That's an automatic red flag, as 99% of them settle. No one wants to risk the trial. Couldn't figure out why. We thought we would get him around 2 million. Other side was offering 700k. So I'm going through the massive file trying to figure out what they have that we don't know about. Looking at his medical, I saw he tested positive for meth a few months after the accident. I was part of the jury selection that morning, and we had 2 people with doctorates, several with masters and professional licenses, most college educated. Really not good for a guy who didn't make it through high school and was a laborer who decided to sit at home and smoke meth after his accident. Ended up settling right before the trial was supposed to start. We got a little more out of them, but far below what we expected. The guy was adamant about not settling, but we talked him into it. He would have been screwed as soon as they brought that up. Divorce client came into my lobby one morning, panicked. She starts screaming about how the money was missing. What money? I asked her. Apparently her and her soon-to-be ex didn't believe in banks, as they kept a suitcase with close to $100k in a safe in their bedroom closet. One morning she saw the safe was open and the money was all gone. You'll have no idea how hard it is to trace and prove the existence of that much money in loose 100s, 50s, and 20s. Cost her several grand in fees alone for how much work went into finding it. When if she had just told us about it we could have placed it into a trust account pending the divorce. Immigration, deportation defense, case. Our defense against deportation required showing exceptional and extremely unusual hardship that my client's US citizen children would suffer if he was deported. I had reviewed the law and facts of the case with him ad nauseam. He and his wife had reviewed their testimony with me a number of times. The children's hardship did not seem like it would be strong enough to win the case because the parents told me that the kids were relatively healthy, doing well in school, and didn't have any other noteworthy issues. All of the documents that they brought in supported their testimony. While testifying in court, the wife admits that they have a child that they had not mentioned before, with a rare medical condition that required trips across the state to see a specialist every few months. During a short recess so I could figure out why they hadn't disclosed this at any point in the last 3 years, they confessed that a family member who knew a lot about this stuff told them that having a citizen child with a serious medical condition hurt their case. The judge denied my request for a continuance to get evidence and expert testimony for the medical issue because they had ample time to provide the evidence before and hadn't disclosed this, and ultimately, the judge denied the application because he found that that portion of their testimony lacked credibility due to it being disclosed at trial and they hadn't provided corroborating evidence. Was prosecuting a simple assault and battery. Story I get before trial is baby daddy shows up and punches new boyfriend before leaving with the kid, who TBF he has custody of because mom tested positive for coke at birth. At the time girlfriend baby mama tells police yup, that's what happened. But, in the meantime she and new boyfriend broke up and now she is back with baby daddy, so her story has changed and she is saying it didn't happen. She isn't credible, so I discount her new version of events and still put the case in front of a jury because the victim is adamant and there was an injury to his face. Defense obviously puts the girl on the stand, where it first comes out that she and the victim weren't Netflix and chilling as reported to police, but were actually doing cocaine and ignoring the baby. The baby daddy apparently knew she did coke at this location, so when he saw her car there he went and pounded on the door demanding their kid. She then says that the victim hit himself in the face to make it look like he was beat up. As she is saying this, the victim starts hitting himself in the head and yelling no. 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 Like the special needs kid the school makes wear a helmet before storming out. The jury went with not guilty, and I understood. Child custody case where I represented grandparents seeking conservatorship of a preteen girl from bad bio parents. Asked all the usual questions in preparation about their home, who lives there, any criminal or CPS history, who the child would be around or alone with. Nothing remarkable. Child care plan involved the girl riding bus home from school and spending a couple hours at home before grandparents returned from work. During the hearing, it comes out on cross of my client that their son, who had recently been released from prison and is required to register as an ex-offender, was residing in a trailer home on the property, where he would have a couple hours per school day with potential access to the child. We still won because the parents were horrible. Client later explained that we only asked them about people living in the home and it didn't seem relevant to them. FASIPM in our firm. Crucial information the client didn't tell us is referred to as having an ex-offender living in the backyard. Right double quotation mark. My client had a no contact order with his ex-girlfriend. He got a call and hang up, dialed 69. It was her. She called the police saying he had violated the no contact order. We show up to court and I think I have a pretty good argument on his side. Two police officers walk up to me and look at my client's name on my case folder when he was in the restroom. When he comes back, they arrest him on an outstanding warrant for armed robbery. I get a continuance for his case. His car gets impounded in the garage. I can't get him transported from the jail to face his violation of a protection order because that is how the police worked in that city. The public defender takes over his cases. I moved away shortly after that, but that was a very bad day for my client. I stopped putting names on my case files after that so no prosecutor or police officer would be tempted to look through them. I worked in family law for a bit, now I'm in PI. One case we got when I was a law clerk for a family law attorney was a guy who was a stay-at-home dad to 6 kids while his wife busted her butt. They lived, essentially, on a farm. The oldest kid was around 13 and wanted to show cows. The youngest was around 2 years old. The point is these people are stupidly wholesome. Except dad comes to us for representation. Out of nowhere, he wants a divorce and so far, representing himself, it's gone completely sideways. His wife kicked him out of the house after claiming she would call the police and claim he was abusing her, so he left the house immediately and now lives in a small apartment. The guardian ad litem is skeptical that he can provide enough space in the apartment for 6 kids and had given his wife primary custody while he gets his life together. Additionally, he hasn't worked for 13 years because he was the SAHD, so getting a job is difficult for him. However, he comes out saying that mom recently left the kids at a public town event all by themselves, including the 2-year-old, for a full day. Essentially, she dropped them off, went to work, and then only picked them up after she had finished her shift, gotten dinner, and relaxed a bit. The kids were completely unsupervised. Dad is furious, says anything could have happened, wants custody removed from her completely. We go to a hearing and meet in the judge's chambers beforehand. What comes out is not what our client has been telling us. Apparently, his sudden desire for a divorce was not so sudden. While his wife was clocking in serious overtime, he started an online relationship with another stay-at-home parent, a mom, who also had a large amount of children. He decided he wanted to leave his wife for this other, still married woman. He also failed to mention to us that the reason his wife threatened to call the police was because she discovered evidence of his cheating everywhere and lost it. She did try to tell the police that he had a gun, but she didn't say he was abusing her. Finally, mom might have left the kids at the event all day, but dad knew about it and didn't do anything. He thought it could help his case if he didn't intervene. Opposing counsel showed us the text messages between mom and dad, with dad telling her on the day of the event, "I can't believe you've left them there. This is going to look so bad for you. Dad, by the way, was still unemployed. He could have picked them up, but he didn't. He was with his lover and her kids that day. We also had messages between mom and dad where dad was attempting to emotionally manipulate mom to giving him more money. He even claimed to have pictures of their children's diaries cataloging the abuse she'd put them through, i.e. eating vegetables, doing their homework, that he was going to use against her unless she paid him $X amount. His financial issues were actually because he kept spending his half of the joint account money on his lover and her kids rather than his own, including trips, clothes, nice dinners, etc. He demanded spousal support, which, technically, he could get, but we had to tell him that if he married his girlfriend before the spousal support time was up, he would lose spousal support. He ended up crying about how it was all so unfair. Yeah, buddy. So was walking into the bonfire of your bulls in front of a judge, but there we were. My position ended. It was just for the winter, before his case finished, but from what I heard from the attorney I worked for, things did not get better. One more for you. My first ever hearing in front of a judge as an attorney was a Social Security disability appeal. My client had been crushed at work a few years ago and his entire left side of his body was mangled. He had PTSD from seeing his dad shoot himself as a kid, loads of mental health issues and physical ones as well. Just my luck, I get the biggest dead judge the SSA has to offer. It's sort of an unspoken rule that you don't interrupt someone's opening statement. You don't make objections, you don't interrupt. Well, I get 3 sentences into my opening and I was listing his conditions, and the judge screams over me, "You forgot one. What about the drug abuse disorder? When was the last time your client did heroin?" I froze for a half a second, glared at said client, and said, "Well, Your Honor, I didn't mention that, similar to how I didn't mention his prediabetes and seasonal allergies. It isn't relevant to his ability to work as he hasn't abused drugs in several years." Additionally, he admitted that he used drugs to cope with his mental health disorders, which he has taken much better control over since he began counseling. I was damn proud of that response. My client won the case. I called to tell him. His GF answered and informed me he was in jail for the next 36 months for stealing a car. Defending a tenant from eviction, the client kept saying she was being evicted because the police were called after her abusive ex showed up. That's actually discrimination, leaving the landlord liable if that was the reason. But landlord's attorney says they're evicting for cause, not the ex thing, and asks whether the tenant told us what she did. I go back and ask if there is anything she hasn't told us. Well, maybe it's the fire I started in the laundry room. I was really coked up and the security footage looks bad. This is about 5 minutes before the judge calls the case from the bench. Woof. They should have told their first lawyer about this. Couple has been divorced for years. The ex-wife approaches me, stating that her husband doesn't want to cooperate in selling their house so they can truly separate. Both ex-wife and ex-husband are still living in the same house that they have lived in for almost 20 years. They are both foreigners but have had residency permits in my country for over 20 years. Divorce judgment is from a court in my country. I ask her a ton of questions. I notice that their registration papers already mention separate addresses. I ask which one is for the house that she wants to sell. None of them. Their house is in another country. They hadn't lived at their registered addresses for decades. Divorce court had no jurisdiction. Divorce judgment appears null and void, and not updating your residency status is a crime. I have no idea how these persons lived their lives for almost 20 years. So, not a lawyer yet, but I interned at a family court helping during hearings. There was this woman filing for custody of her children, and her lawyer was pretty confident they'd win, since in my country women getting the custody is almost an unspoken rule. In the rare cases they don't, either they don't want it or there's a very strong reason for the children not to be with their mother. So, as I was saying, Her lawyer seemed very confident. It was practically a one case. Until her client's ex-husband mentioned in the middle of the hearing that his ex-wife was an addict and lived in a non-monogamous relationship with 2 other addicts. To make matters worse, the woman's parents confirmed his story. The lawyer very obviously did not know about it and was visibly pissed at her client. I swear I saw her mouth to the woman, "You'll have to find a new lawyer." Apostrophe. A lady applied to be a legal assistant at my firm. She casually mentioned that she knew me and some clients I had. My boss ran it by me when he said her name. I told him yes, I indeed knew who this lady was. My clients were the ones applying for custody of her kids to get them away from her. Her file with Child Family Services was as thick as a tome. Application declined. More than 19 children. Oh man, one I can answer. I used to work in-house for a fast food franchisor. Occasionally we would litigate against poor restaurant operators. Restaurants were evaluated with some frequency and operators had a lot of opportunity to fix problems before it ever got to litigation, but almost all of our case relied upon the testimony of an individual evaluator assigned to that restaurant and the reports they produced. A week before the hearing I call up my witness to do standard witness prep. I walk through all of the basic questions, the reports themselves, and some of the anticipated cross-examination questions. Everything goes well. Witness is confident, reports look good, and there aren't any curveballs in his prep. I even ask my tried and true safety question at the end. Is there anything we haven't discussed, good or bad, that you think I should know? Nope. I think I'm all set. We get into the hearing. I run through all of my evidence. All as planned. Restaurant operator gets up to cross-examine my witness. First question. RO, did you fall asleep in my restaurant while you were preparing this report? Witness, yes, restaurant owner made him look like a drug addict. Thankfully I was able to get a brief moment with my witness before redirect and I learned that it was a medical issue. We still won that one, but WTF. 3 children. By far the most egregious I've had was in the middle of a workers' compensation mediation. My client had suffered an injury on a worksite job and the mediation was going okay. He was hoping for the stars, moon, and sun, but the employer was offering something that was fair enough to take. Then my client pulls me aside, hours into the mediation, and tells me for the first time in the entire course of representing him, over a year, that the injury he suffered at work was really from a previous injury he had at a prior job. In other words, he didn't have a workers' comp case at all, and all because he wasn't honest with me for over a year. I flat out told him that he needed to take the settlement offer right then and there and walk away from the case, or else I would have too. Fortunately, he did take the settlement. Unfortunately, he and his wife badmouthed me and called me a bad lawyer to pretty much anyone they could talk to. They didn't go to the bar or anything, but it's super petty to turn around and say someone's bad because you lied to them. Of course, I'm used to it now. It stung a little way back then though. And this isn't like some of my other clients who have a drug problem, lie about it, and cannot accept that they have a drug problem. This guy knew exactly what he was doing. He lied to me to get me to take his case. If I had been more experienced, maybe I would have caught something in his older medical records, but the other side didn't either. This isn't quite as good as the others in this thread, but once I was representing a dude pro bono who was suing the cops for beating the S out of him after they had arrested him. He had led them on a high-speed chase through the suburbs, which was already not great, but the rule of law should apply to everyone, and the cops are not allowed to beat the S out of you after you've been restrained. So a tough case, but whatever, you're the lawyer, you do what you can. In one of our first meetings with him, we're going over that night. I asked if he had had anything to drink, and he admitted that he had, a beer or two around 8 PM. The chase was at 2 AM, and as you should know, alcohol leaves the system at a rate of roughly 1 drink per hour. so we were probably fine there, and if anything, it was nice to have a client who wasn't pretending everything was perfect. We move on and talk about the rest of the night. Then as we're wrapping up, our freaking summer intern of all people goes, "Did you do any other substances that night besides alcohol?" And the client's like, "Oh, right, yeah, some marijuana and some coke." Dude. You didn't think that was relevant when we were talking about a couple beers? The lesson I took though was that the ones who are the most charming are the ones you have to press the most. Case I was working on just the other month. Boundary dispute with the neighbor. Thought it was all fine and dandy until a disclosure from the other side of a video of my client pouring liquid human excrement on the garage door of his neighbor's property. Fair to say we got laughed out at trial. Defending a client against a complaint of racial discrimination from a contractor. Matter proceeds through all preliminaries, disclosure and heads for trial. In passing 2 weeks before trial, client mentions that he and the contractor were sleeping together for several years and stopped around 2 months before the complaint. I shared this earlier in a thread, but I work in medical malpractice defense. Once I had an obstetrician gynecologist who severely burned a patient during a procedure. When I met with the doctor, he lied to me throughout the representation over 16 months, saying he had no idea how it happened. There is a doctrine in law called res ipsa, meaning absent some sort of negligence, this accident could not have occurred. Woman came in without a burn, and after the procedure, the woman left with a burn the size of a dinner plate. There's no way this doctor didn't know what had happened. The area of the burn was where he was operating on. It wasn't until I brought up settlement, because this was not a case we could win, did he say, "Oh, maybe I do know what happened." We ultimately settled that case, which is considered a favorable outcome considering the potential high monetary verdict. Sometimes I think this doctor really ought to have lost that case and their license. Eventually it was discovered that the lamp used to illuminate the site of the procedure emitted a ton of heat, enough to cause serious burns. I cross-examined a character witness. He testified how badly the plaintiff was injured and that they have lived together for the past 3 years. The witness saw how devastating the injury, subject of the suit, was to the plaintiff. Character witness was the brother of the plaintiff. Witness testified that he had not lived anywhere else over the past 3 years, always lived with his brother during that time, so he saw how the injuries affected the plaintiff every single day. The character witness was convicted of raping a child 15 years prior and was a registered ex-offender. He moved from another state and failed to register in the current state as an ex-offender. About 18 months prior to his testimony, the witness was convicted of failing to register as an ex-offender. He was sentenced to 12 months in prison and served 6 months of that sentence in federal pen, during the time in which he claimed to be living with his brother. I asked him if he lived anywhere else in the past 3 years several times. His testimony was never anywhere else. I asked him about his child rape conviction, his conviction for failing to register as an ex-offender, violation of the terms of his parole, he could not be around children, he also lived with his sister and her small children. And about his time in the federal pen. His response, "Oh, I forgot about that." He was not a compelling witness to say the least. I know the other attorney and we were talking after the case resolved, and he mentioned that the character witness should have mentioned he was a convicted rapist prior to testifying. And yes, the witness was reported for violating his parole. His parole officer was made aware of the living situation. Police officer, I know, MR. Defendant, I've arrested him on 3 prior occasions and he always gets away. After 7 attempts to prep this witness to find out what can kill the case and his career, he stonewalled me every time. I even said I'd prep him during his night shift. This case hinged upon the police officer's credibility. Now the police officer shocks the court and me with his bias against the defendant. Anyway, if I knew about this bias, I would have dismissed the case. Now, the police officer is on an official court ruling as a non-credible witness. His career is over. All because he decided he was too important to be prepped as a witness. If I didn't document every time I contacted him to schedule prepping, I would have had hell to pay at my office. Had a major civil rights case in federal court arising from a police shooting where the guy died. Turns out the police had an entire internal investigation file that they didn't let us know about. That was not fun to explain to the judge. Had to help a man obtain asylum in my country because he was being wrongfully threatened by other families back home. During asylum interview, I explained he had a blank criminal record and he was a model citizen. Apparently the interviewers found out the guy was a convicted murderer in 2 countries and a war criminal. Asylum was denied. Used to do public defender work. At bond hearings, prosecutors discuss the client's entire criminal history to the judge in an effort to deny bond and make the client seem as dangerous as possible. It always told my clients, I need to know your complete criminal history before we go to the judge, because if it's good, then I'm going to work the angle, and if it's bad I am just going to keep my mouth shut. But don't lie, because once the prosecutor opens their mouth if it contradicts what I said, you're going to be the one looking like a liar, not me. I've had a few major blows. Each client told me that they had never ever been arrested before. So that's what I tell the judge. Your Honor, my client deserves to be given a signature bond because they've never been arrested before and are innocent until proven guilty. Well. Client 1. Convicted of rape at 17 years old. Sealed conviction, so I guess he didn't think it was going to come up. Client 2. Convicted of manslaughter reduced from murder. Client 3. The prosecutor hands me a copy of their criminal history, 17 convictions. I just look at him and ask, did you forget about the 4 felonies you plead guilty to over the past 3 years? Add to clarify, in my office we didn't receive criminal histories until down the line, so we often went in blind and relied solely on information provided by clients. Thank you for watching. Don't forget to like, subscribe and leave a comment.